If you're in a split custody arrangement, you would probably love to be able to control what happens with your child in the other parent's household. For example, maybe you've been taking your kid to soccer practice or some other extracurricular activity, and the kid's really into it, loves it, is doing well, but the soccer practice takes place during the other parent's parenting time. You'd probably love to be able to say that other parent has to go to soccer practice or whatever other extracurricular you picked out. Or maybe you're in a situation where you've been trying to come up with legal decisions about your child and you've just been running into walls and you've been talking to the other parent and they just never agree, or they just fight you for the sake of fighting, or they're just making decisions that don't make any sense. I am Arizona attorney David Enevoltson, and in this video I want to talk to you a little bit about a recent decision that came out of the Arizona Court of Appeals addressing these issues. The case is called Paul E. v. Courtney F., and it came out in 2018, if this is when you're watching it. That's when it's being filmed. So if you're watching it way later, obviously this isn't so recent, but the basic idea is it's addressing these issues in terms of how much authority the court has to resolve these things. Now, the general concept is that it's scaling back what kinds of authorities the court can do in terms of interjecting itself into the place of parents. And the idea here is that the court can't parent in place of the parents. And so there's a real restriction in terms of looking at the court kind of coming in and trying to micromanage what's going on during a parent's parenting time. The court has the ability to say, okay, you have parenting time, parent A, parent B, mom, dad, you're going to have the child from this time till this time. Other parent, you're going to have the child from this time till this time. But the court can't come in and say, okay, you've got to go to soccer practice or whatever other thing you've got going on. You can't say, here's the specific things you're going to do during your parenting time. It's just outside of the court's authority. Now, the parents can't agree to this. They could stipulate to, here's what we're going to do, and they could put that together in an order and sign it off that way, but the court doesn't have the ability on its own to come in and try to micromanage what's going on. Now, in a similar sense, the court can't put in its own judgment for purposes of legal decisions. Now, with that, what we're talking about is if the parents are at an impasse with a decision, a legal decision. So for example, if you needed to pick a doctor and one parent was saying, okay, we need to go to Dr. A, another parent saying, no, we need to go to Dr. B, the court can't come in and say, all right, I'm going to pick Dr. A, or I'm going to pick Dr. B, or some totally different doctor, I'm going to pick Dr. C, because that would be the court coming in and putting its own assessment about how to parent this child. You can't do that. The only thing the court can do with respect to legal decisions is it can come in and say, okay, you guys aren't agreeing for whatever reason, so I'm going to designate mom or I'm going to designate dad as the person that is going to make these legal decisions. So it's a really interesting case because it's a bit of a shift in thought from how we've looked at this previously, which for a lot of people I think was to run to the court and say, we're at an impasse, judge, I need you to do this specific thing in terms of parenting. And the court simply can't do that. Now, there is one exception with respect to the parenting time equation of this, and that is to say that if your child is in a situation where he or she is going to be endangered, then the court can take restrictions or impose restrictions on parenting time that are going to ensure that the child is safe. But that's very different from coming in and micromanaging specific parenting time activities and saying the kid or the parent has to do this or cannot do this during parenting time, so long as it's a safe thing. You know, if you're talking about the parent is going to be locking the child up in a box of broken glass, you're probably going to have restrictions on that parent's parenting time, but you can't say, okay, you have to go to soccer practice during your parenting time. All very interesting, kind of new developments. For some people, this may seem obvious already because this is sort of what the law said, but it's a little bit of a different shift in terms of what many people were looking at this in with respect to what the family court can do. And it's certainly different from what a lot of parents want the family court to do. If you have any questions about your parenting time situation or your legal decision-making situation, I highly encourage you to talk to a family court attorney, a family law attorney that's licensed to practice in your state, and specifically somebody that knows what they're talking about in this particular area. Just find out some basic rights and legal rights and obligations that you might have to just make sure that if you are in the midst of a case, you are not making some sort of an error.